Reddy Neumann Brown, we bring in live updates every Tuesday from 5 p.m. to 6 p.m. Central Time. We do take a lot of questions, live questions. And what do we have today? Every time we bring in bad news. Do we have any bad news today?
We do have some good news today. We did get an update that that deals with the automatic extension of certain EADs. It's going to be 540 days instead of the usual 180 days. That's going to be a permanent change through the regulatory process. We'll talk about what that means, who all qualifies for it, and whether the new administration could reverse it. Is that something that we have to worry about? We will also talk about whether the current administration can do other things to help employment-based immigrants. Particularly, there is a policy change that's been proposed to grant EADs to people who have an I-140 approved and are waiting in the backlog. I think the current kind of proposal is for people who've been waiting for 5 years, but there's no right or wrong answer on that. So can that be done? Will it be done? How can we make that happen? We do have some somewhat bad news coming on the EB-5 front. For right now, as we've talked before, that is the only category that's current for someone from India who's not filed a petition yet. You could turn around tomorrow and file that immigrant petition, as well as the adjustment of status in the EB-5 set-aside categories. It's the only category you can do that if you were born in India. That is about to end. That window of opportunity is closing. So we'll talk about why and what to prepare for there. And then lastly, we want to talk about advanced paroles and the I-94 that you get when you re-enter the U.S. using your advanced parole. You may have a 5-year advanced parole, but the I-94 you get is only valid for 1 year. Is that a problem? Do you need to extend it? What is the situation with that? So going back to the 540-day update, so do you want to give us kind of a rundown of what's going on with it?
Emily, as we know that when the EAD expires for adjustment of status, we'll discuss one at a time. The adjustment of status, when they file the extension previously, long time ago before Biden came in, if the EAD does not get the approval, then they have to stop working. And you cannot file the EAD extension unless it is within the 6 months window. Obviously, Biden administration did extend it that it's 100. I don't remember whether it was Biden or Trump, but I remember Biden administration did extended it that if the EAD is still pending, you can still work for a period of 180 days if you file the EAD extension before the EAD expires. This is, we are speaking about employment-based adjustment of status and in some cases, family-based adjustment of status cases. Extensions only. When the EAD extension is pending, you can work for 180 days. As our audiences already know that, it was been extended for 540 days. That means that those people, instead of 180 days, the same thing, if the extension has been filed properly, then they can work for 540 days. So that's a very good relief for people because sometimes these EADs, they don't come proper timing, and USCIS delays the EAD approvals, but they can still working based on the extension receipt notice, which is a very good news for a lot of people though. Now, it has been extended for the H-4 EADs too, where if the H-4 is extended and H-4 EAD extension has been filed and extension is pending, they could also work for 140-day rule. But here, there is a small catch point here for the H-4 EAD. The H-4 must have been approved. That's a catch point. But there are some ways out, Emily, when people, if they would contact us earlier, there are ways people can go to Mexico if the main spouse H-1B is approved and their I-94 is still valid. They can go to Mexico and come back and get, based on their spouse's H-1B, they can get the I-94 extended. They also can go for stamping when the extension is pending and get the stamping. And based on the stamping and coming back into this country, they can also work for 140 days rule. It's not an absolutely very, very good news for the H-4 EAD, but definitely it's much better relief though. Now, going forward in the Trump administration, we were thinking that they may scrap this rule, but they're issuing the regulations. They said that they're going to issue regulations on this Friday only. So hopefully, everything will be fine. Regulations won't be undone by the Trump administration. And if they have to do it, most probably they have to go to the Congress, which they may, but most probably they are not. This may not be that important for them to go for scrapping this one. But this is a very good news for a lot of people who are in adjustment of status, for the H-4 EAD people also to a greater extent, Emily. Anything
Yeah,
else?
and I just want to point out that it does not apply to the STEM OPT. So those that are on F1 that have the 12-month OPT expiring and you qualify for the STEM extension, when you timely file your STEM extension, you do get a 180-day automatic EAD extension while you're waiting for your STEM extension to be approved. That does not change. That does not increase to 540 days. So for STEM OPT, it's still only 180 days. And I think a lot of people also are still not getting the idea that the H-4 EAD is not always automatically extended. In fact, in most cases, it is not automatically extended because you're filing the H-1B, the H-4, and the H-4 EAD all together. And so the only way the H-4 EAD auto extension kicks in is if both the H-1B and the H-4 have already been extended, but the EAD is still pending. That's a very limited situation because usually if you're following our recommendations, you're filing early, you're filing in premium processing, and you're getting all three approved together before the expiration of the current H-4 EAD, so you don't have to worry about it. But we may have a situation where premium processing gets suspended. That happened before under the Trump administration. And we may have the situation where they stop bundling the H1, H4, and H4 EAD. That settlement agreement expires in January. We're working to see if we can get it extended. But as of now, that could go away. So in that situation, people should be prepared to understand that in order to get the auto extension of the EAD, they have to somehow get the H-4 extended. There are ways to do it by travel. So just plan ahead and make sure we have a video that completely covers that topic if you review that on our YouTube channel.
Emily, we have seen Biden administration give employment authorizations to a lot of people. We have seen Obama administration giving employment authorization to a lot of people. In fact, when I looked into the EAD codes, though, if somebody wants to go to USCIS website and look into what are the EAD codes, there are so plenty of those things, including the people when Nepal got the earthquakes, they gave a temporary protection status and gave employment authorization, and still they're continuing extending those EADs right now. And some of the South American countries fall into the same line. Can this Biden administration, before they leave, can they give the employment authorization for the people whose I-140 has been approved for more than 1 year, 5 years?
They do have the authority to do it. It's pretty clear in all of the litigation that surrounded the H-4 EAD, that surrounded the STEM OPT, that surrounded DACA, and all of these different programs. The courts have consistently said that USCIS, through the executive branch, has the power to grant employment authorization to classes of individuals. So yes, they could decide that the next class of individuals they are going to grant employment authorization to are people who have an I-140 approved and have waited for a set period of time and cannot file the 485. I mean, that's basically like an H-4 EAD because you get that because your spouse has an I-140 approved and is not able to file the 485. So can they extend that to the H-1B holders themselves? Yeah, I think they do have the authority to do that. Is Biden likely to do that in the next 30, 40, 50 days before he leaves office? I don't know about that. And I don't expect the Trump administration to do that, but it's possible.
Yeah, it's just less than 50 days left for the Trump administration to come in. This administration is taking a lot of decisions on the immigration, Emily. And you can see that things are coming up. Yes, they can do it. I want all the people to contact the administration. We have provided the link below where you can write to the administration to have the employment authorization be granted to the people whose I-140 has been approved. So please, we want all of you guys, if you think so that you want the EAD, if the I-140 has already been approved, please write letters to the administration because this is a time. The law between us and the Trump administration does not exist. At least we know that. I don't know if you're understanding or not. I see that a lot of channels, a lot of lawyers are telling that there is no love between Trump administration and the people who are intending to immigrate into the United States, who are legally abiding and paying taxes in the United States on a non-immigrant visa. There is no love in the air between Trump administration. So if there is anything that could come in, it should be coming in the next 50 days. If it doesn't come in, anything that comes out after 50 days, I can say that there's a 90% probability anything that is going to come from the Trump administration is not going to be good for the non-immigrants and for the children who are going to be born here in the United States for these non-immigrants. So if there is anything that could be achieved right now is the time. And we have given the drafts, we have given the links there at the bottom. Please proceed if you think so, that you want an EAD if an I-140 has been approved for you and you haven't filed the adjustment of status. Yes, under the authority, they can give the employment authorization. Emily, in this EB-5 though, I mean, we've been advocating people, hey, you know, priority dates are not going to be current for employment-based 1, 2, 3. 1 is also backlog. Most people may not be eligible for 1, but at least they're eligible for the 2nd and 3rd category. And we have given a blanket notification that if they file the green card right now, they may not get them in their lifetime if things go under normal circumstances. However, the EB-5 has been current for a while for Indian nationals. Is there any danger for it for EB-5?
Yeah, so what has allowed EB-5 to be current for India when regular EB-5 has not been current is the set-aside provision that is for rural infrastructure and high unemployment areas. There are a number of green cards set aside in those areas each year. And really the only reason we have these available is because USCIS takes forever to process the I-526 petitions. And so they have all of these cases in the pipeline, but until they actually approve the petitions, those visa numbers just sit there waiting. So we can say that there are all visas available. Nothing's being used up right now. And now that USCIS is starting to approve more and more of those petitions, once they approve enough of them, it will use up all of the available green cards in that category. So you see in the January visa bulletin, the Department of State included a statement saying that the current demand in the EB-5 set-asides is increasing or has been higher because USCIS is finally adjudicating those cases. That means they are going to run out and they're going to have to implement a cutoff date. That means retrogression for EB-5. Everyone's very familiar with that in EB-1, 2, and 3. So if you are considering EB-5, it's now or never if you want to be able to file a 485 along with it, be able to lock in your child's age, and be able to actually receive the green card in your lifetime, unless you qualify for EB-1 and have an older priority date that you can port. But other than that, EB-5 is really your only option for a somewhat faster green card for people that are born in India.
Advanced parole, this question is coming very frequently. We do have a daily Zoom call where every day from past 12 years, we've been conducting every working day where people come and ask questions. It was used to be a conference call. Now it's a Zoom call where people can ask questions. We're getting this call that people, let's say nowadays, they do have a 5-year advance parole. That means that it's valid for 5 years. When they enter into the United States in the I-94, that means when they enter the online I-94, only gives them permit for 1 year. Their main question is that, do they need to extend that I-94 or do they need to change to non-immigrant visa? They have to go outside the country, they have to apply for the extension. The answer is no to all the questions. If you have an advance parole and you travel outside the country, and let's say you entered into the country in May of 2024, and your advance parole is expiring, the online I-94 is expiring in May of 2025, and you have an advance parole that is valid until 2027, for example, you can stay in the country, absolutely not a problem. You can use the advanced parole that is valid until 2027, absolutely not a problem. Now, on the contrary, there is one danger. Let's say, for example, your advanced parole is expiring in December of 2020, December 30th of 2024, and you entered into United States in May of 2024, and now on the online status, the advanced paroles, the I-94 says that advanced parole expires in May of 2024. Can you use that to travel outside the country and come back in? The answer is clearly no. So the only thing that you have to trust right now is the advanced parole card or document that you have been given, but not the online I-94 that says what advanced parole validity is. Anything else, Emily?
I think we can go to questions.
Raj has an interesting question. Can you speak about the birthright citizenship for newborns next year where parents are on GCEAD or H-1B? This is a very controversial question that is coming out. And there are some estimates that we can do at this point of time. There is what Trump has been saying all along in the election campaign, that on the day one, he's going to bar the birthright citizenship for the illegal aliens, the people who are illegally present, is what he said. Now, there is a Donald Trump website when the election campaign where he clearly indicated, because in the election speeches, they don't have a lot of time to explain all the details. So when you go to these campaign things, donaldtrump.com, where they have given the details with regards to whom they intend to bar. They said that in the Donald Trump website, though, where it says that only the people, if one of the parent is either a green card holder or a US citizen, they will be allowed to have a birth certificate. Otherwise, he will issue an executive order banning those people to get the citizenship. Now, there's also Stephen Miller, who is the advisor for the Trump on immigration, who says that he's going to go back and denaturalize the people who are born to who are illegally present in this country. Now, I definitely don't think so that Trump is going to abide with what Stephen Miller is saying, though, but he does not intend to go back. He made it very clear he does not intend to go back. That's for sure. Now, whether he is going to bar only for the people who are born to illegal, or will he bar citizenship for the people who are also legally on H-1B but not on green card, we don't know yet. Once the executive order comes in, we will be able to know what is in there, because they haven't leaked that information. They've been telling that illegal people, but at the same time, website is telling something different. So it's very hard for us right now to judge there is. But one thing we already discussed separately in a YouTube previously on the birthright citizenship and how we can challenge that legally. So we already discussed about that. Now we're going to challenge it legally, though. Now we may want to challenge this separately, though, because there's already law firms that are ready to fight for the people whose children are born, whose parents are not legally present in this country. We don't want to mix with them, because if we lose, they lose. We don't want to lose with them. We may want to have a private representation where we should have a right where if the person is legally present in the country. Now, if you go back to the 14th Amendment, though, that was done a long time ago, what the amendment says is that anybody who's born in United States, on the land of United States, will be given US citizenship. There is a slight exemption for it, that for those people whose the US government does not have any control over, their children will not be given citizenship. And that practice has been going on. For example, for the ambassadors and the consulate officials, the US government does not have an authority of them. For example, I'll tell you, if some ambassador, he's driving a car, he commits an accident, which is a crime, and then he drives, technically speaking, the police or the FBI cannot arrest him. There are some limitations what the police and FBI can do for these ambassadors. So for those people, their children will not be considered to be US citizens because the US government does not have an authority on it. What the Trump is trying to tell is that the people who are illegally present in this country, he does not have a control. Since he does not have a control, he's going to make that exemption to not grant the U.S. citizenship in his executive order. Now, when it comes to the legal immigrants, hey, we came with a visa. The U.S. government approved, the USCIS approved the H-1B. Then we went to the consulate. They approved the H-1B. Then the CBP allowed us to enter into the country. And we have the driving license, we have the H-1B, we're paying taxes. We are under the control of the United States is the argument that we are making. But we will see on January 20th when the executive order comes in, and we will prepare a fight if needed at that point of time if they include the legally present people in the executive order.
All right. Suvarna from YouTube says, I am an Indian-born registered nurse working in California on an H-4 EAD. For getting my own legal status, is it better to go with the Schedule A petition or my own H-1B? Well, the Schedule A I-140 petition does not give you any work authorization and does not give you any status. So although you would want that in order to finally receive the green card if you were born in India, and the Schedule A falls under either EB2 or EB3, you're not going to see a green card anytime in your lifetime if you haven't started that process now under the current law. So that means you need a way to have status and be able to work. And so an H-1B would be the route that you take now. You'll still need the Schedule A by the time your 6-year limit of H-1B is reached, because then you'll be able to keep extending the H-1B beyond the 6th year based on having that Schedule A I-140 approval.
One second. People are asking.
Says, oh, sorry, go ahead.
People are asking about the letters for the EAD. If we have kept it, it seems that it's not there, but we're going to update in the next, as soon as this YouTube is over, we're going to put that information in there, where we're going to provide the links where you can write the letters to the administration.
Siddhartha says, will backlogged EB1 visa categories get any love from the new administration, given the fact that the incoming First Lady came in as an EB1? No, I don't expect that at all. The issue with the backlog in EB1 has nothing to do with the administration. It has everything to do with the number of people in the pipeline in EB1. They already have enough applications in the pipeline to use up all of this year's 2025 green cards. So you're not going to see any movement in EB1, maybe a month or two at the most, until from now until October 2025. And then maybe a little bit of movement after that when we get into next year's. But that's, again, looking at the number of I-140 approvals. There's enough I-140 approvals in 2023 to also use up all of the green cards that are becoming available in EB1 India. So EB1 is going to continue to be backlogged based on the number of people that are filing in that category. Nothing that the administration can do about it other than advancing the filing date chart by making some sort of change to the definition of when a visa or immigrant visa becomes available. But that's something that would apply to the entire visa bulletin, not just EB1, and is very unlikely under the incoming administration.
Question is with regards to, the gentleman is asking whether he's working for a full-time company, and do you expect any problem in visa stampings at the time when you go for the visa stamping in the Trump administration? I would say that if it's a full-time job, when people have gone for visa stamping, we have seen very less problems. On the contrary, though, if it's a consulting companies and if they're working through, let's say, for example, the end client is Pepsi and they're working for a consulting company, and we have seen some problems, especially in the consulate. And especially if they're working, like, let's say, there's Pepsi and there's Deloitte, and they're actually working for a the client, vendor, and employer, where there are 3 people involved in there, then we definitely have seen a lot more troubles in getting the stamping in the Trump administration. But
even working as a full-time employee, if there's a travel ban, which there was before. People couldn't get the stamp at all unless they got a exemption from the presidential proclamation.
Yes.
So we may see travel bans again. Rajesh says, regarding the J1 visa 2-year waiver of the home country residence rule that just came out this week, will this apply for medical residents to eliminate requiring the 2 years of work in a remote area? No, it does not apply to physicians, unfortunately. I mean, good for the remote areas because we need doctors there, but not so good for the physicians who have to work in those areas to get the waiver.
Can the administration ban the cross-country chargeability where an Indian person get married to the rest of the world person and they will be counted with the rest of the world? As you know that the rest of the world is well advanced. So if one spouse is from a different country, you can use the other spouse, even though that spouse is not the main applicant, even though the spouse is a dependent. No, this administration cannot undo it. It is there it is passed in the parliament, so it has to go to the parliament. I don't think so that Trump administration has that on their menu at this point of time. Question from Raghu Charan, can the administration block H-4 EAD by executive order? No, they have to go through either regulations or through the Congress. By just blocking through, because it's been done through the regulations, they have to go through the regulations.
Home CED says, is there a third round of the H-1B lottery this year? No, actually USCIS came out and confirmed that they've used up the entire cap with the 2 rounds of the lottery. So they are issuing non-selection notices to everybody in the My USCIS account. So there will not be another lottery. The next time will be in March for the 2025 visas that will become available in October 2025.
Is it okay for the L1A holder to come from a different port of entry than what is mentioned in the petition? Absolutely not a problem. You can come from a different one. Raghavendra has this question. Do you hear anything about merit-based and point system? We yet don't know. I mean, of course, this was a proposal by the Trump administration. We yet don't know, but it has to go to the Congress. The parliament is called Congress here. And I don't think so they have enough votes to pass it in the parliament. And Raghavendra, we still have one other problem though. Even if they pass it, will they take the per country limit out of it? Because if they don't take the per country limit out of it, Indians are going to face a huge problem, even if it's a merit-based thing. If they take the per country limit off and they do the merit-based though, then definitely Indians may fare better because of their education, because of their English, because of their salary, because of the job, the kind of jobs that they're doing, they may fare better. But if they put the per country limit, the Indians will still have a significant problem, significant hurdles in getting through the merit-based system.
KM says, I got laid off on H-1B and my 60-day grace period starts December 10th. But as per my I-94 on my last entry into the U.S., the admit until date is December 29th, 2024. Can I stay in the country past this date till the end of my 60-day grace period? Or am I required to take action prior to this date? So I'm assuming that the last time you entered, since then, you've not filed an extension with USCIS and obtained a new I-94 that extends your stay beyond December 29th. So assuming that's the case, you need to be aware that the 60-day grace period is cut short based on your I-94. So if your I-94 is expiring before 60 days, your grace period is however many days you have left on your I-94. So you absolutely will need to take action before December 29th, either exiting the country, filing a change of status to B2, filing a change of status to H-4, depending on what your situation is.
Vamshi is asking question, Emily, I want your attention also. Are you hearing anything in the lame duck session, Emily, on immigration?
Nothing.
No, I'm not hearing.
It's like crickets.
Yes, the election results were really surprising for both the parties, for the Democrats and the Republicans. People are really shocked that it's been completely wiped out. All the battleground states have been won by one party. So people were completely shocked. They are still not able to digest it. There are some things the administration is doing, especially those things are working out internationally, mostly in Syria, and they're doing something in Ukraine, but I haven't seen much buzz about the immigration. People are just trying to defend themselves that once this government will come in, how are we going to defend these people? How are we going to, we will take up the challenges in the Supreme Court. These are the things that people are speaking about more than getting it passed in the lame duck session. One thing we should not forget that in the lame duck session also there is something called filibuster. That means that it requires 60 votes. So if one senator from Republican Party puts a hold on the case, then we are doomed. And most probably some of the Republicans may not cooperate, so the Democrats don't have the 60 votes to pass any of the legislation. And they don't want to do away with, the Democrats don't want to do away with the filibuster because it's going to work very against when the new administration will come in. So definitely Democrats don't have enough votes to pass any bill in there. So we'll have to see if there is any bipartisan that is going to come in. Emily, Trump has signaled that he may be willing to do a bipartisan bill, though. That's something I've never heard from Trump, though. Especially when it comes to the DACA kids, though. He said he may not want to deport them. He said that some of these people have been working, they have been doing business, they're settled here, they have kids. I may do something with the bipartisan, with the help of Democrats, he said, MD. So do you think so that something big may come in? Because he may use them as a bargaining chip to do something on his own and maybe get the merit-based system or something like that can come up. Because I've seen, I mean, especially after the elections, though, that when it comes to the DACA kids, he has been speaking very softly about DACA kids. In his election speech, even after the election speech, also, he did not speak of the undocumented aliens who got 1 million employment authorization given by the USCIS, which is the DACA kids, which we call them as dreamers. He hasn't spoken anything against them, and he hasn't spoken that he's going to deport them either, Emily.
Yeah, I do think that he will use them as a bargaining chip because he is planning this mass deportation effort. He's planning to expand the wall. All these enforcement things require funding. So how's he going to get that funding? It has to come through Congress. Well, they're not going to agree to all this enforcement funding unless he also compromises on some other things, such as helping the DACA kids, helping the legal dreamers, doing some sort of merit-based immigration. And according to Trump, he's a master negotiator. So we'll see if he's able to come up with some sort of compromise.
Let's see. I mean, I've seen that. I've worked on some of the cases on what Ronald Reagan has done. He is the most conservative person, is most anti-immigrant. At that time, back in olden days, that was in 80 Assembly. I don't know whether you were born or not, maybe you were. But yeah, I did work on, I wasn't a lawyer at that time, but I did work on some of the cases that were passed at that point of time. So let's see how the things will turn out, as the things will go. Let's keep a positive attitude and at the same time be prepared if there is anything that will come in.
There was a question about H-4 EAD. If I apply for my H-4 EAD now and get approval that's valid till 2027, what if Trump comes in and eliminates the H-4 EAD next year? Will mine still be valid? So we won't know until there's an actual regulation published. But historically, when the government is taking away some kind of benefit, they don't go back and revoke already approved applications. So it would be very unlikely, in my opinion, that your EAD would be invalidated. I think most likely he would block new people from filing and may not allow further extensions but I don't think he's going to go back and take away already issued EADs. But that's kind of just a guess based on historically how different agencies have handled similar situations.
Do I need an I-140 with my new employer to file the H-4 EAD? I have an I-140 approval with the old employer, assuming that the previous I-140 was not withdrawn for 6 months after it's been approved. You do not need a new I-94 with a new company to file for the H-4 EAD. This question is coming from Twitter, from Special.
Street says, will there be any travel ban on H-1B holders who've been in the U.S. for the last 4 years? It's certainly a possibility. We had one before, and Trump's platform says specifically that he wants to re-implement various travel bans. Now, he doesn't specifically say the H&L travel ban, which is what he did before, and that H&L travel ban was supposedly in response to the economic situation and the fallout of the COVID pandemic. So if we're not going through a COVID pandemic and the economy is doing fine, does he have a reason that he could use to implement an H&L travel ban? I don't know, maybe not. But if there's anything happening in the economy, if the unemployment rate goes up, maybe there are certain industries with high unemployment, or he just wants to seal the border. I mean, his platform says he wants to seal the border on day one. And in order to accomplish that, he could implement a travel ban for H&L as well. So it definitely is a possibility. We've seen it happen before, and it could absolutely happen again.
The question is coming from Akhil with regards to that he has an I-140 approval with the previous employer. Does he need to have an I-140 approval with the current employer right now? No, you actually don't need to have a current employer with you right now, I-140 right now, because as long as the date is not current, you can still use it to obtain the immigration benefits from your current employer.
Sunil says, my old passport already expired, but I have a valid visa stamp in that passport that's good till 2026. I've already renewed my passport. Can I travel with that H-1B visa in the old passport and the new passport? Yes, you can. That visa remains valid, even though that passport has expired. So just carry both when you're traveling.
Does my wife need to apply for H-4 plus GCEAD? She has a H-4 EAD, just in case the Trump administration is going to put some restriction on H-4 EAD. Now, if you are in adjustment of status, so irrespective whether you are an H-1B, H-4 EAD, please apply for the EAD. Irrespective of, please apply for the advanced parole and please apply for the EAD. Do both of those things.
Not a bot says, my H-1B got approved under consular processing in October 2024. Can I change my approved H-1B to a change of status with the same employer? Yes, assuming that you are in the U.S. and properly maintaining your current status and will maintain it up until the time of filing. Yes, that can be done with the same employer. You cannot do it with a different employer, however.
Yeah, STEM OPT travel ban, we don't know yet, but definitely it's a risky one compared to OPT, compared to the H-1B, compared to the H-4. I'd say that STEM OPT is a little bit more riskier, and I would be very cautious. So please keep tuning to Reddy Neumann so that if there is any updates, we'll let you know. Right now, it's anybody's guess right now.
Ashish from X says, is there any issue with traveling to India after January 20th? I have my Dropbox appointment January 30th. My visa expires July 2025. My employer will file the extension after I return back. There's definitely some risk. I mean, again, Trump has said on day one he plans to seal the border. What if he does that while you're outside the country and you have no way to get back? It happened before. There was H&L travel bans that people could not get the visa so that they could not travel back to the U.S. People were stuck outside for months, some even years. Will that absolutely happen on day one? We don't know. Will it affect H-1Bs? We don't know. But there's definitely a possibility there. So I really think you have to weigh the purpose of your trip. Since you already have a valid visa through July 2025, if you're just going for vacation or something like that, maybe if it's not a mandatory trip, don't worry about it. Not a good time to go. But if like a family member is, hospitalized and, you need to travel for an emergency situation, if you feel that that is more important than your ability to get back into the US, then maybe it is a good idea to travel. So you really have to weigh the reason for the travel to determine if it's really worth the risk of getting stuck outside the US. If you get stuck outside the US 6 months from now, will you say, I'm glad I took this trip? Or will you be kicking yourself because you took that trip?
Question. My priority date is 2018. My wife is going to apply EB-1A. Can we move the priority date of mine to my wife and apply the adjustment of status if the I-140 is approved? The answer is no, you cannot. If you have an I-140 in EB-1, definitely you can, but you can't move your EB-2 to your wife's EB-1 application.
Maruthi says, my priority date is in 2015. My kid is 15 years old on H-4. I'm not expecting the priority date to be current before my kid turns 21. When should I start the F1 process for my kid? So you don't really need to start it until they're around 20. Obviously, it has to be filed before they turn 21 because their H-4 will expire then. Currently, we do have premium processing for the change of status from H-4 to F1, and we no longer have the requirement of the bridge B2 filings if the processing time takes so long that the H-4 status expires while the F1 is pending. Both of those could go away under a Trump administration. So you really just need to watch the trends and understand whether it's taking longer than
people are asking with regards to the links for the drafts. Unfortunately, it's not there right now. As soon as this live show is over, I'm going to put those drafts in there, and you can have those. You'll be able to write the letters to the administration for the removal of the per country, having the EAD for those people whose I-140 has been approved. We're facing some technical difficulties, guys, from Emily's side, but I will continue answering these questions. Question with regards to H-4 EAD. I filed my H-4 and EAD together, but only H-4 has been approved. The EAD has not been approved. Unfortunately, that happens sometimes, not all the times. But if you want to avoid those kind of things, the best way is to file along with H-1B, H-4 and EAD. If you file together, you can contact our office. We can contact the USCIS and get it. But if it's only H-4 plus EAD that's been applied, we cannot contact the USCIS, but it doesn't come under the agreement between the AILA, American Immigration Lawyers, and the USCIS, where they have to apply it together, though. Questions with regards to, I have filed my 485 in 2020. My 485 has not been approved. My priority date is not current. When would I get the green card? Now, until your priority date is not current, you would not be able to get the green card. So you have to wait for the priority date to be current. Okay. Question with regards to applying his wife is on STEM OPT. He got his I-140 approved. Can he apply the adjustment? Can he apply the H-4 plus EAD for his wife? Absolutely, you can. 95% of the time, they do approve the H-4 and EAD together. There are 5% of the time they may not approve the EAD. But 95% of the time, they do approve H-4 plus EAD together. It's not a guaranteed, but most probably they will.
Sorry about that. I lost Wi-Fi in the office for some reason.
Question from Prabha Sahu. The GC holder, I've been a GC holder from past 2.5 years. It's been 2.5 years for me to left for filing the citizenship. I got married in January. I haven't filed I-130 for my wife. Can she apply for student visa? She can, but most probably she will get an student visa denied because she has to declare in the I-130 that she's been married. And if she does not, though, it will be considered to be fraud. So if she declares, then she most probably will not be given. I would recommend that you file an I-130 immediately. And the problem is that it may be 2 to 3 years for her to come here on the green card. So that's a problem there.
John says, my EAD expires in May 2025. This is a 485 AOS EAD. Do I have to renew it, or is it automatically renewed based on the latest news? You still need to file the renewal application, and you really should be filing it now or in January at the latest. Once you file the I-765 application to renew that, once you hit May 2025, you can continue working for up to 540 days while that application is still in process in case it's not approved in time, but you do have to file for the renewal.
Can travel ban forward the EB2 and EB3 green cards? Not likely though, because most of the people are in United States, especially employment-based immigration. Yeah, under some limited circumstances, so if the family immigrant visas, they hold it up. And those, the rule that says that is that if there is a certain limit for family immigration, if they ban or if they stop issuing the family immigration, those excess green cards will fall into the employment based. And that's what happened in the COVID period because they couldn't process the family immigration. That's the reason the priority dates moved for almost 4 to 5 years because the excess green cards came from family immigration and fell into the employment. Yeah, there are only if they restrict the family immigration, then there's a chances for it.
Kareem says, for switching from H-1B to F-1, is it going to be a problem if I have an I-140 approved? It can be because the F-1 is a non-immigrant intent visa. You have to establish that you have a residence abroad that you do not intend to abandon and that your stay in the U.S. on F-1 is going to be temporary and that you intend to return home at the end of your stay. So having the approved I-140 can suggest otherwise, that you intend to stay here permanently. It's not the only factor they look at, but it could trigger a request for evidence asking for you to prove your non-immigrant intent.
Question is coming from Anant Roy and some other people where their priority date is current and they're not approving the 482 application and it's been pending for a while. The best option is to sue the USCIS. That's the best option. For that, you can contact Stephen Brown in our office. Like Reddy Neumann Brown, he's the third partner in our office. You can contact him. He should be able to help you out. You can drop an email at steven@rnlawgroup.com.
Ahmed says, will travel ban affect advanced parole holders? It all depends on how the travel ban is worded. So it'll come in an executive order, a presidential proclamation. It'll be posted on the whitehouse.gov website, and it will have very specific language about who it applies to and who it doesn't. The prior travel bans never impacted people who had an advanced parole. They were still able to come in. The travel bans before impacted people who were applying for H-1B visas, L visas, people from certain countries, as well as people who are applying for the immigrant visa or the green card at consulates outside the U.S. Those were all of the different categories previously that were subject to travel bans. We don't know what Trump has planned. We don't know if he would expand that, if he would be able to or plan to block people from coming in who have an advanced parole.
Is there any problem for stamping H-1B visas in India? I would say that there is any difference If there is any difference, it's only 1 to 2% difference, but no, I haven't seen any significant problems in the stamping in India at this point of time.
RB says, I have a H-1B cap approval and stamp, did not work or travel with that employer. Can I come to the U.S. with a different employer by transferring the H-1B cap petition? Yes, assuming that visa has not expired, it's not been revoked, the petition has not been revoked due to fraud or anything like that. A new employer can file an H-1B petition that is not subject to the cap, not going through the lottery, and request consular processing. And once it's approved, you can travel using your existing visa stamp with the new employer's approval notice.
Am I eligible for national interest waiver? I have a master's degree in 7 years. That by itself is not eligible for national interest waiver. There are other things that need to be considered. Whether your work is very important to United States. There is a YouTube video we've made on national interest waiver. I want you to watch that one. It's about 7 to 10 minutes, but just your experience and master's degree is by itself is not enough.
Shopna says, my priority date is under EB2. Is it a good idea to downgrade to EB3 since the EB3 filing date is ahead and EB2 is behind? Potentially. We definitely had a lot of people that downgraded to EB3. It's happened many times over the years, but most recently in October 2020, they were able to receive the green card faster by doing that. We also had people who did it and then EB2 and EB3 flip-flopped to where EB2 became current while the EB3 was backlogged. And we had to do either a transfer of underlying basis to move the case back to the EB2 I-140, or some people filed a second 485 when the EB2 date became current. So yes, it can be beneficial to you. It also might be a waste of time and money. So it really depends on whether you just want to take the opportunity to try to get a faster green card through EB3.
H-4 and EAD has been applied together. H-4 has been approved. If I travel right now, will there be any problem for the EAD? The answer is clearly no. Since your H-4 is already approved, EAD will be adjudicated even if you travel. Absolutely not a problem.
Question was, is it a good time to travel to the U.S. for the first time on H-1B after January 20th? If you have the visa stamp and you have the job available in the U.S., I would try to get here before January 20th because we just don't know. I mean, Trump has said that he wants to seal the border on day one. He has said that he wants to implement travel bans again. Will that happen on January 20th to block your entry? After that, potentially. We just don't know. But it is certainly in the realm of possibilities. And I'd hate for people to end up stuck outside the U.S. when they could have come here if they just modified their travel schedule a little bit.
If I get laid off, is it a problem moving into F1? What about the H-4 status? This question is from Kareem from YouTube. We have noticed a lot of uptick with regards to the RFEs that are coming in when people are moving from H1 to F1. The main thing that they are asking for is if they want a statement why you want to move from H1B to F1. What's the purpose why you want to study? So that need to be clearly defined, especially if it's a day one CPT university colleges. We're seeing a lot of problems on a lot of RFEs coming for the day one CPT colleges. So particularly, you need to write the purpose why you are moving, you want the F1 visa. With regards to the H4 status, so when you apply for F1, you can apply for the F2 status for your spouse.
Pat says, EB3 registered nurse with an approved I-140 and a pending 485, and I recently changed jobs. When should I file for AC-21, and do I need the new employer to file an I-140? You can submit an I-485 Supplement J anytime in order to let USCIS know that you've changed jobs and that the new job is similar to the job you were originally sponsored for, so you qualify for AC-21. You want to make sure, again, your I-140 is approved, which you mentioned, but also that your 485 is pending for at least 180 days. That being said, we have found it not so much necessary to proactively submit the 485 Supplement J. We've kind of changed our stance on that over the years. And so nowadays we would say, if you don't have an RFE asking for it, just wait for the RFE, wait for an interview, and you can submit it at that time. It doesn't really do much good to submit it before they're requesting it. Unless your old employer plans to withdraw the approved I-140, sometimes that can trigger an RFE asking for that Supplement J. And you do not need a new I-140 in that situation, because AC-21 allows you to take the approved I-140 and 485 with you to the new employer as long as the jobs are similar and as long as the 485 has been pending for 180 days.
My H-1B stamping is going to expire in February 20th, 2025. Can I go for stamping to Mexico with valid I-797? Absolutely. If you get an appointment, you definitely can go for stamping.
Nikia 11 says, is there a chance that the processing of new H-4 EADs will become faster with the new rules? Because they're currently taking 8 months in Nevada. I do not have high hopes for that. You know, one would have thought that since USCIS started issuing 5-year EADs, it cut down on the need for people to be constantly applying for renewals of the AOS EADs, that would create more efficiency and allow them to process other EADs faster. And that just hasn't happened. They have not done anything to improve processing times, even though we pay higher fees, even though we pay this extra asylum processing fee. So no, I don't expect things to get any better when it comes to processing times. Even with our Department of Government Efficiency, I think resources will likely be taken away from USCIS and geared more towards enforcement, more towards the border, more towards asylum, and away from legal immigrants, unfortunately.
Second.
Mohit says, with an approved I-140 and the priority date is not current, can we apply for an EAD? There is a compelling circumstances EAD option if you are experiencing compelling circumstances. It's kind of an EAD of last resort because it does not provide you with any status and it does not provide you with a way to travel. And if you use it, you would not be eligible to file for an adjustment of status until you get back into some sort of non-immigrant status like an H-1B work visa. So yes, there is an I-140 EAD if you are experiencing compelling circumstances. For example, you lost your job on H-1B and you're dealing with paying for a mortgage, you've got kids' daycare to pay for, you're losing your health insurance, you know, you've just got the regular life bills to deal with. That could all combine to be a compelling circumstance to provide you with an EAD. So at least you can work at another employer that's unrestricted, but you do lose your status when you do that and you can't travel using that EAD.
Nay Andre has this question. I'm an H-1B and can I travel on advance parole and come back into the United States? Absolutely, you can. And here's a question: can I travel on advance parole for a leisure vacation? Absolutely, you can. You can.
Vamshi Krishna says, who all gets the 540-day automatic extension? My category is C26. So C26 is for the H-4 EAD, so you kind of get it. You don't get it simply because you filed your H-4 and H-4 EAD extension on time. It only works if your H-4 has already been extended beyond the validity of your current EAD and you filed your EAD renewal on time. There is a list of all of the EADs that do qualify for the 540-day automatic extension, I shared it recently on my Twitter, on X, if you follow Immigration Girl there. It's pretty easy to just Google it and find it as well. But for C-26, remember, it's not exactly automatic. You have to have the I-94 of your H-4 extended in order to qualify.
Question with regards to, can I apply for EAD when my priority date is not current? Mohit, no, you cannot. But can the administration allow us? If the government wants us, they can. And that's what I'm going to give a link to you in the next 10 minutes. So you can follow the link and write a letter to the administration to allow you to file the EAD. But they're not allowing. If they allow you, you can file the EAD. But for now, the rule says that you cannot file the EAD if the priority date is not correct. Anything else, Emily?
Nope, I think we are out of time for today. Thanks for joining. Be sure to subscribe to our newsletter by going to rnlawgroup.com so that you'll get updates on all of the changes that are going to be happening over the next 4 years with the Trump administration. It was definitely a wild ride before, and we do keep you updated on that. And of course, subscribe to our YouTube channel so you get updated whenever we go live and post any new videos as well.